let's say this child has special needs. Now, this child has an asset. Now, if you know a little bit about Medicaid, a primary residence is not a countable resource. So, as long as the child's living in that house, that 22% interest isn't going to disqualify them. But let's say instead of a house, that was a brokerage account that had $100,000 in it. Now this child has $22,000 in resources. Guess what we have to do with that $22,000 before they're again eligible? And this even applies to the deeming waiver, because the deeming waiver just simply ignores the parent's income and resources. It does not ignore the child's income and resources. And by law, this child would now have that 22% interest. It is a countable resource even for the Katie Beckett deeming waiver. So we would then have to do something with that $22,000. Medicaid takes a very dim view of a Medicaid recipient simply saying, oh, I don't want it. You can't do that. If you do that, it's an improper transfer of an asset. So there's going to be a penalty period equal to, and then they'll calculate what it is. Some other problems or other ways assets accidentally or intentionally wind up in the child's name is an improperly drafted will. Many times a will be drafted so that it'll include that child. Well, that can be a problem. Another problem is an improperly drafted trust. And trust can be either in a will or a standalone trust. But if that trust doesn't contain specific language, Medicaid and SSI is going to review that trust and say, you know what, trustee, you have the legal obligation to support this child. Doesn't matter how old the child is either. If you have the legal obligation to support the child with this money, then all of that money is a countable resource. And Medicaid and SSI is absolutely right. If there's a legally enforceable right that that child must be supported by that money, then Medicaid and SSI is going to count that money, even though it's in a trust. And the trouble with it being in a trust, we have less options of what to do with it. So an improperly drafted trust is actually more problematic than, giving the child the money outright, because then it's a little bit easier to fix. It still involves the court. It still involves significant costs, but it can be fixed. With an improperly drafted trust, what we wind up having to do is go and reform that trust. That's a little bit more complicated and involves the superior court rather than the probate court. So it can get more costly very quickly. So it all depends on how much money is involved, whether it's even worth doing.